हेलो फ्यूचर जजेस, आज हम पढ़ने जा रहे हैं स्पेसिफिक रिलीफ एक्ट 1963। स्पेसिफिक रिलीफ एक्ट 1963 हमें बताता है कि डैमेजेस, कॉम्पनसेशन और मनी रिकवरी के अलावा हमारे पास क्या क्या और रेमेडीज अवेलेबल हैं। स्पेसिफिक रिलीफ होता क्या है, दैट वी आर गोइंग टू अंडरस्टैंड टुडे। In today's class, we will understand the history of specific relief and how Specific Relief Act 1963 came into being. What are the major legal maxims related to Specific Relief Act 1963? So students, what is specific relief? What is the definition of specific relief? Specific relief is a species against the general reliefs. It is a species against the general reliefs of damages, compensation and money recovery. ये एक तरह का स्पीशी है उन जनरल रिलीफ्स के अगेंस्ट जो कि हमें दूसरे सिविल लॉज में प्रोवाइडेड हैं, यानी कि डैमेजेस, कॉम्पनसेशन और मनी रिकवरी, जो हमें कॉन्ट्रैक्ट लॉ में भी मिल जाती है, सिविल प्रोसीजर कोड में भी मिल जाती है। सो इनके अगेंस्ट स्पेसिफिक रिलीफ एक स्पीशी की तरह उभर के आता है। सो लेट अस अंडरस्टैंड कि स्पेसिफिक रिलीफ की ये डेफिनेशन आई कहां से। स्पेसिफिक रिलीफ की ये डेफिनेशन हमें दी गई अपेक्स कोर्ट के द्वारा इन आधुनिक स्टील्स लिमिटेड वर्सेस Adhanik Steels Limited versus Orissa Manganese and Minerals Private Limited. Orissa Manganese and Minerals Private Limited में, जो कि 2007 का सुप्रीम कोर्ट का एक लैंडमार्क जजमेंट है। 2007 में सुप्रीम कोर्ट ने इस केस में ये डेफिनेशन दी दैट स्पेसिफिक रिलीफ इज अ स्पीशी अगेंस्ट द जनरल रिलीफ। तो हम जानेंगे कि स्पेसिफिक रिलीफ की हिस्ट्री क्या है। द हिस्ट्री ऑफ स्पेसिफिक रिलीफ गोज बैक टू 1760 इन द फेमस इंग्लिश केस ऑफ मोसेस वर्सेस मैकफर्लान। मोसेस वर्सेस मैकफर्लान, इस केस में जो कि एक किंग्स बेंच का जजमेंट है, 1760 में किंग्स बेंच ने इंग्लैंड में कुछ प्रिंसिपल्स बताए थे जिनके बेसिस पे स्पेसिफिक रिलीफ अवार्ड किया जाता है। व्हाट इज द अंडरलाइंग प्रिंसिपल ऑफ स्पेसिफिक रिलीफ वर गिवन अंडर द मोसेस वर्सेस मैकफर्लान एक्ट, मैकफर्लान केस 1760 किंग्स बेंच। So in this case the court discussed two major principles. The two major principles that were discussed by the court were, firstly, doctrine of unjust enrichment. Doctrine of unjust enrichment. Doctrine of unjust enrichment ये कहता है कि you cannot benefit yourself at the expense of another. किसी दूसरे के एक्सपेंस पे आप अपना फायदा नहीं करवा सकते। Doctrine of unjust enrichment states that you cannot gain something at the loss of another person. Yes. The other doctrine that was held to be instrumental was doctrine of quantum merit. Doctrine of quantum merit, जिसे हमने कॉन्ट्रैक्ट लॉ में भी पढ़ा या सुना होगा। Doctrine of quantum merit ये कहता है that everyone should be paid for as much as they have earned. Quantum merit, that a person must be paid for what they have earned, as much as they have earned, as much as they deserve. इसे एक छोटे एग्जाम्पल से समझते हैं। For instance, A contracts with B to form 3 rooms on his property. 3 rooms are to be constructed on A's property. Now, B will be getting, let's say, 9,000 rupees for constructing these rooms. B asks A for the money in advance. B asks A for the 9,000 rupees in advance. Now A gives him the 9,000 rupees in advance. But after taking the 9,000 rupees in advance, A says that I cannot complete this contract and I will not be able to construct the 3 rooms on your property. So what A does, A asks B to return the money back, to refund the 9,000 rupees that he has already paid in advance. So here B refuses to give the money back. B says that I have spent all your money and I will not be able to return your money. Here in this case, B is getting unjustly enriched. He is getting unjustly enriched by the amount of 9,000. A के 9,000 रुपीस के लॉस पे B अपना 9,000 रुपीस का फायदा करवा रहा है, जिसके लिए उसके पास कोई लीगल बेसिस नहीं है. He is earning these 9,000 rupees at the loss of A, at the expense of A. So this is what is stated in the doctrine of unjust enrichment, that this is unjust, inequitable. This is against the principles of equity, justice and good conscience. In the same example, let us consider that A tells B to construct 3 rooms on his property and B is able to construct 2 rooms within the given amount of time. So, after constructing 2 rooms, B asks A for the amount of 6,000 rupees. B says that I have successfully constructed 2 rooms on your property. So kindly pay me 6,000 rupees for the work I have done. Thereafter, I will construct the 3rd room. Now, A is having a change of intention and A says that no, I will not provide you 6,000 rupees. I will give you the whole amount of 9,000 rupees only when you construct the 3rd room. When all the 3 rooms are constructed, then I will give you the money. So in this case, A is avoiding to pay 6,000 rupees, which are legally, rightfully earned by B. B has earned the right to have these 6,000 rupees of payment. This is against the doctrine of quantum merit. This is against the doctrine of quantum merit. So in Moses versus Macfarlane, Lord Mansfield has stated that the principles of specific relief, they are based on equity, justice and good conscience. Equity, justice and good conscience. यानी कि साम्य, न्याय और सद्विवेक. So, if these principles are not followed, then any person cannot claim a specific relief for their matter. Now, moving on to the more modern history of specific relief in India. According to this case of 1760, a pre-independence law was formulated in the year 1877. In this law, which was called Specific Relief Act of 1877, in this law, many judicial interpretations were given. So much that this law became so bulky and heavy and it was proving to be ineffective for the Indian legal system. This law was lacking in many features that we required for our legal system. So, the Law Commission of India, in its ninth report, the Law Commission of India recommended that we should have a new law for specific relief. In that ninth report, the Law Commission discussed the various features that should be included in the new Specific Relief Act. So, on the basis of this ninth report, a new Specific Relief Act was formulated and passed by the Parliament. This law is what we today know as Specific Relief Act 1963. This law is what we today know of as Specific Relief Act 1963. So, the Specific Relief Act 1963 was given assent of the President on 13th December 1963 and it came into force It came into force on 1st of March, 1st of March 1964. These questions are generally important from the point of view of preliminary examinations. So you need to remember the date of enforcement for the purposes of preliminary examinations. Now, the extent and applicability of this act has been discussed in section 1 of the act. According to section 1, the act is applicable to whole of India. The act is now applicable to whole of India, which was earlier not the case because of the Jammu and Kashmir Reorganization Act. The Jammu and Kashmir Reorganization Act 2019. According to Schedule 5 of the Jammu and Kashmir Reorganization Act 2019, many central laws are now made applicable for whole of India, including the Union Territories of Jammu and Kashmir and Ladakh. So, Specific Relief Act was made applicable to state of Jammu and Kashmir as well through this act. Let us move on to the next question, the next section, which is section 2. Section 2 of the act gives us definitions of the act. It gives us meanings of the words that are used in the act. Section 2A obligation को define करता है. It defines an obligation. Obligation is said to be a duty enforceable by law. It is said to be a duty enforceable by law. Now we have to understand the two most important elements of this definition. The first is duty and the second element is enforceability by law. So let us understand this by an example. Let us say that the Municipal Council of Delhi passes a rule. It passes a rule. The Municipal Council of Delhi passes a rule that no one can play loud music after 10 p.m. No one should play loud music after 10 p.m. The first question that comes to our mind, whether this rule, is it a law? Yes, this rule is a law because it comes under the definition of a delegated legislation. The assembly, the state assembly has given the right to Municipal Council of Delhi to maintain order and peace in the territory of Delhi. So they are able to form this rule, which is a law as per the definition of law under Article 13 of the Constitution of India. This is a delegated legislation. So this rule is a law that no one should play loud music after 10 p.m. in the city of Delhi. Now let us say that your neighbor is violating this rule. Your neighbor is violating this rule. He is playing loud music after 10 p.m. in your neighborhood and that is disturbing your peace. So what you can do is you can file for an injunction against your neighbor. You can say in the court claiming specific relief against the neighbor that the neighbor is hampering with your enjoyment of your property. You want the neighbor to be permanently stopped from playing loud music after 10 p.m. So, does the neighbor have a duty? Yes. Is the duty enforceable by law? The duty not to play loud music. जी हाँ, तो इस केस में जो आप स्पेसिफिक रिलीफ मांग रहे हैं वो बिल्कुल वैलिड है, बिकॉज एक ऑब्लिगेशन है नेबर के ऊपर जिस ऑब्लिगेशन का उस नेबर ने वायलेशन किया है. तो मूविंग ऑन टू सेक्शन 2B. 2 क्लॉज B हमें बताता है सेटलमेंट के बारे में. सेटलमेंट के बारे में बताता है कि सेटलमेंट एक तरह का इंस्ट्रूमेंट है. इट इज एन इंस्ट्रूमेंट एंड इट इज नॉट अ विल और अ कोडिसल एज पर इंडियन सक्सेशन एक्ट 1925. कोडिसल भी नहीं है एज पर इंडियन सक्सेशन एक्ट 1925. दिस इज नाइदर अ विल नॉर अ कोडिसल. आई होप आप सब विल का कॉन्सेप्ट जानते हैं, जहां पे एक टेस्टेटर अपनी प्रॉपर्टी का डिवोल्यूशन बताता है कि किसके ऊपर होगा, कैसे होगा आफ्टर हिज और हर डेथ. That is the concept of will. But what is a codicil? A codicil is a document which is an amendment in the will. It is an addition in the will or a subtraction in the will. Now this codicil may be attached with the original will so that the original will is not needed to be amended again and again. The original will be valid along with this codicil. So now this instrument is not a will, it's neither a will, it's neither a codicil. Then what is this instrument? This instrument, settlement, is an instrument whereby the destination or devolution of successive interests, destination and devolution of successive interests is done of what? Of property. Destination or devolution of successive interests in property. Property could be movable or immovable. Destination और devolution किसका किया जाता है? Property का किया जाता है, which could be movable or immovable. And इसके लिए ये एक तरह का agreement भी हो सकता है. It could be destination or devolution or an agreement to do the destination or devolution of the movable or immovable property. So here what we see is that in that a settlement is not an instrument. It is not an instrument. It is an instrument which is not a will or a codicil. It is an instrument which is not a will or a codicil, but it still tells us about the destination and devolution of successive interests in the movable or immovable property. So for instance, if A says to B, that I will give you my car, on 19th April 2024, and in exchange B might have promised something, or he might not have promised something. We don't know that. But this instrument in which A has written that I will give you my car, which will devolve on you on 19th April 2024. This will be a settlement. This is a simple example of what a settlement is. So, moving on to clause C of the definition clause. Clause C of the definition clause tells us a trust. What is a trust? It is as defined in section 3 of Indian Trust Act. Indian Trust Act section 3 में जो ट्रस्ट की डेफिनेशन दी गई है वही डेफिनेशन SRA यानी कि स्पेसिफिक रिलीफ एक्ट में भी अप्लाई होगी. इसके साथ ही ये भी बताया गया है कि इंडियन ट्रस्ट एक्ट के चैप्टर 9 में जो ऑब्लिगेशन इन द नेचर ऑफ ट्रस्ट दिए गए हैं वो भी अप्लाई होंगे. दे आर ऑल्सो इंक्लूडेड इन द डेफिनेशन ऑफ ट्रस्ट. सो यहां पे ट्रस्ट का मतलब क्या है? दैट which is included in section 3 of Indian Trust Act and that which is included in chapter 9 of Indian Trust Act. Let us move on to clause D. Clause D हमें trustee के बारे में बताता है. Trustee is the person, trustee is includes every person holding property in trust. Trustee is every person holding property in trust. So a trustee is every person who is holding any property. जरूरी नहीं है कि वो property movable हो. It could be movable or immovable. This person becomes a trustee under the Specific Relief Act. I hope all of you are aware with the concept of trust. But let me give you a small example to make you understand what a trust is. A ने अपनी एक पर्टिकुलर प्रॉपर्टी को B को एंट्रस्ट कर दिया है. A says to B that derive the benefits out of my property. मेरी प्रॉपर्टी से मिलने वाले सारे रेंट्स, रेट्स, सब कुछ आप जो हैं कलेक्ट कीजिए मेरी प्रॉपर्टी का केयर कीजिए, उसकी सिक्योरिटी का ध्यान रखिए, एंड whatever the amount is created with these benefits, ये अमाउंट आप एक बैंक अकाउंट में डालिए. Put this amount in a bank account and use this bank account for the education of my children in future. This is a example of a trust. यहाँ पे entrustment हुआ है प्रॉपर्टी का, entrustment हुआ है प्रॉपर्टी का, A की प्रॉपर्टी का B को हुआ है, so B becomes the trustee. B is the trustee of the property, and the children who will receive the amount out of this bank account become the beneficiaries of the trust. They become the beneficiaries of the trust. This is a small example of what a trust is and how a trust is created. Moving on to section 2 clause E. Clause E हमें बताता है that all the words and expressions that have been used, all the words and expressions जिन्हें SRA में use तो किया गया है but define नहीं किया गया है, words used but not defined under Specific Relief Act, these words have the same meanings that are assigned to them under Indian Contract Act. Indian Contract Act में इन वर्ड्स का जो मीनिंग दिया हुआ है, जो डेफिनेशन दिया हुआ है, that same definition will apply for Specific Relief Act. For instance, Specific Relief Act talks about specific performance of contracts. It talks about substituted performance of contracts. But Specific Relief Act में कहीं पे भी contract की definition provided नहीं है. तो ऐसे में Specific Relief Act कॉन्ट्रैक्ट की डेफिनेशन को बोरो करेगा इंडियन कॉन्ट्रैक्ट एक्ट से, जहां पे सेक्शन 2H में कॉन्ट्रैक्ट को डिफाइन किया गया है. दिस इज द मीनिंग ऑफ क्लॉज E, that the definitions that are not present in the Specific Relief Act may be borrowed from Indian Contract Act 1872. Let's move on to section 3 of Specific Relief Act. Section 3 of Specific Relief Act talks about savings. It saves certain things from the operation of Specific Relief Act. Save करना यानी कि बचाना, बचाव करना. Let us understand what is being saved by the operation of Specific Relief Act. Section 3 says, except as otherwise provided in this act, which means कि एक्ट में अगर कहीं पे किसी जगह कोई एक्सेप्शन दिया हुआ है तो उसे छोड़कर दिस प्रोविजन विल अप्लाई. एक्सेप्ट एज अदरवाइज एज प्रोवाइडेड इन दिस एक्ट, नथिंग इन दिस एक्ट शैल बी डीम्ड, नथिंग इन दिस एक्ट शैल बी डीम्ड टू deprive any person of any right to relief. Deprive any person of any right to relief that other than specific performance, any right to relief other than specific performance that he may have earned, that he may have under any other law relating to contracts. Now, a person is coming under SRA for a contract and claiming specific performance of contract, but that person is also at the same time having a right under Indian Contract Act as well. He has a right to get damages or compensation for the breach of contract under Indian Contract Act. The meaning of this clause is that this right of damages is protected under Indian Contract Act. This right cannot be taken away by Specific Relief Act. Even if the Specific Relief Act में जो आपका केस है वो फॉल कर जाता है, वो रिजेक्ट हो जाता है, then also this person will have a right to claim damages. This right to claim damages is not affected by Specific Relief Act. That person will not be deprived of any right to relief that he may have under any other laws relating to contracts. The second part, the clause B of this section 3 states that nothing shall be deemed to affect operation of Indian Registration Act. Indian Registration Act 1908 के ऊपर स्पेसिफिक रिलीफ एक्ट के प्रोविजंस ओवरराइड नहीं कर सकते. स्पेसिफिक रिलीफ एक्ट will not change or affect the operation of Indian Registration Act on documents. कैसे? If Indian Registration Act is stating that a document must be registered, it is mandatory to register a particular document, then that document must be registered first in order to claim a relief or a specific relief under the SRA. In order to claim specific relief under SRA, that document must be first registered. So, in short, the provisions of Indian Registration Act override the provisions of Specific Relief Act. These provisions are saved from the operation of Specific Relief Act. Let us move on to Section 4 of Specific Relief Act. Section 4 of Specific Relief Act tells us that specific relief must be granted, can be granted only for individual civil rights, only for enforcement of individual civil rights, and not for the mere purpose of enforcing penal laws. यहाँ पे दो phrases हैं, दो words हैं जिनका हमें ध्यान रखना है. इंडिविजुअल सिविल राइट्स को पहले हम समझेंगे. इंडिविजुअल सिविल राइट्स से क्या मीनिंग निकाला जा सकता है? These are the rights which are born out of civil laws. These are the rights which are born out of civil laws. दो लोगों के बीच में जो rights और duties civil laws की वजह से create होती हैं, उन्हें individual civil rights कहा जाता है. For example, Contract Act, Transfer of Property Act, Sale of Goods Act, Partnership Act, Limited Liability Partnership Act, etc. Also, tort law, law of torts as well. All of these are examples of individual civil rights. Now, between two persons, if a matter is coming up under SOGA or Partnership Act, Contract Act, TPA, torts, then that person may ask for a relief under Specific Relief Act as well. जी हाँ, वो Specific Relief Act में भी relief claim कर सकते हैं और contract या TPA या फिर sale of goods या partnership में जो relief उनके पास में available है वो भी वो claim कर सकते हैं. So, this is the concept of individual civil rights. Now, you might have a doubt. You might think कि fundamental rights भी तो individual civil rights होते हैं. Fundamental rights come under a larger bracket called civil and political rights. Therefore, they are claimed against the state. Civil and political rights which are claimed against the state. So, these rights are not called individual civil rights. Because ये individual के against claim बहुत ही कम cases में होते हैं. Largely and generally, ये claim होते हैं state के against. So, this is the meaning of individual civil rights under section 4. Now, let's understand not for enforcement of penal laws, not for the mere enforcement of penal laws. Penal laws के mere enforcement के लिए ये use नहीं किया जा सकता. इसका मतलब ये है that if a court is denying you a relief, let us say that आपके घर में चोरी होती है. For instance, आपके घर में चोरी होती है और आपके पास में एविडेंस है कि चोर ने क्या क्या चोरी किया है और चोर कौन है. You go in front of a criminal court and try to prove that X person is the thief and he has stolen your property. Now, in this case, the court sees that there is reasonable doubt. So, the court acquits the thief. Court जो है चोर को अक्विट कर देता है। नाउ द क्वेश्चन अराइजेस, कैन यू आस्क अ क्रिमिनल कोर्ट, कैन यू कंपेल अ क्रिमिनल कोर्ट, क्या आप क्रिमिनल कोर्ट के अगेंस्ट इंजंक्शन ले सकते हैं दैट आई हैव द एविडेंस, नाउ इट इज योर ड्यूटी टू गिव मी रिलीफ अंडर क्रिमिनल लॉज? नो, आप ऐसा नहीं कर सकते हैं। तो स्पेसिफिक रिलीफ एक्ट को पीनल लॉज के एनफोर्समेंट के लिए यूज नहीं किया जा सकता है। इट कैन बी यूज ओनली फॉर द पर्पस ऑफ individual civil rights. Now, moving on to Section 5 and Chapter 1 of Specific Relief Act. Chapter 1 of Specific Relief Act, Part 2, tells us about the first specific relief. The first specific relief that is provided in Chapter 1 is of recovery of possession. रिकवरी किसकी होगी? पोजेशन की होगी। किस चीज का पोजेशन होगा? प्रॉपर्टी का पोजेशन होगा, मूवेबल या इमूवेबल। मूवेबल या इमूवेबल प्रॉपर्टी का पोजेशन पाने के लिए, उसे रिकवर करने के लिए हमारे पास में चैप्टर 1 दिया हुआ है। सो लेट अस अंडरस्टैंड द वेरी फर्स्ट सेक्शन ऑफ चैप्टर 1 व्हिच इज सेक्शन 5. Section 5 talks about recovery of specific immovable property. A person entitled to the possession of specific property, specific immovable property. तो इसमें जो फर्स्ट एसेंशियल एलिमेंट है वो है entitled का. A person entitled to the possession of, जो second important element है वो है possession. Entitled to the possession of specific immovable property. स्पेसिफिक इमूवेबल प्रॉपर्टी की बात की जा रही है, यानी कि मूवेबल प्रॉपर्टी इसमें इंक्लूडेड नहीं है. अ पर्सन एंटाइटल्ड टू द पोजेशन ऑफ स्पेसिफिक इमूवेबल प्रॉपर्टी मे फाइल अ सूट फॉर द रिकवरी ऑफ द प्रॉपर्टी इन द मैनर प्रोवाइडेड अंडर सिविल प्रोसीजर कोड 1908. सिविल प्रोसीजर कोड 1908 में जो मैनर प्रोवाइड किया गया है सूट्स फाइल करने का, वो मैनर फॉलो करते हुए ये इंसान जिसके पास में पोजेशन है वो एक सूट फाइल करके इस पोजेशन को रिकवर कर सकता है, जो एंटाइटल है इस पोजेशन के लिए. हम समझते हैं कि एंटाइटलमेंट क्या होता है, पोजेशन क्या होता है और सीपीसी में मैनर क्या है. लेट अस बिगिन विद द मैनर. सीपीसी के सेक्शंस 15 to 20 जो हैं वो आपको सूट्स के इंस्टीट्यूशन के बारे में बताते हैं. वो आपको बताते हैं कि एक इमूवेबल प्रॉपर्टी का जो सूट है वो उस जगह में किया जा सकता है जहां पर इमूवेबल प्रॉपर्टी सिचुएटेड है. अ सूट फॉर एन इमूवेबल प्रॉपर्टी मे बी इंस्टीट्यूटेड इन द प्लेस वेयर द प्रॉपर्टी इज सिचुएटेड. नाउ कमिंग टू एंटाइटलमेंट. एंटाइटल का मतलब क्या होता है? एंटाइटल आता है टाइटल वर्ड से, which means ownership. A person who is entitled to possession by the virtue of ownership can claim possession, can recover possession under section 5. जी हाँ, जिस इंसान के पास में possession ownership से नहीं आया है, जिसके पास में possession ownership से नहीं आया है, वो section 5 में सूट फाइल नहीं कर सकता. Only the person who is entitled to the possession by the virtue of ownership can file a case under section 5. Let us come to the meaning of possession here. The meaning of possession is, it has been provided in the Maria Margarida case. In the Maria Margarida case, the meaning of possession was held to include both physical and constructive possession. तो इसमें आपका रियल मटेरियल या फिजिकल पोजेशन भी इंक्लूड होगा, साथ ही साथ आपका कंस्ट्रक्टिव या फिर सिंबॉलिक जो पोजेशन है वो भी इंक्लूड होगा. तो इस तरह हमने ये देखा कि एंटाइटल्ड होना चाहिए पोजेशन के लिए और उसके पास एक स्पेसिफिक इमूवेबल प्रॉपर्टी होनी चाहिए और सीपीसी 1908 के मैनर में वो ये क्लेम कर सकता है. दैट इज ऑल फॉर टुडे. थैंक यू फॉर वॉचिंग.